Welcome everyone to the DRBF Insight webinar series, Liabilities of Dispute Boards and Dispute Board Members. I am Georgiana Takuch, a member of the DRBF Board of Directors Region 2, representing Europe, and I'm your host for today. For those of you who are new to DRBF, the Dispute Resolution Board Foundation was established in 1996 by the creators of the dispute board process, with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has almost 1,000 members in over 70 countries, as the dispute board process has expanded worldwide and is now used on a variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers trainings and educational resources for project owners, contractors and DB practitioners, and partners with other industry organizations to adapt the DB process for new sectors. It may be of interest for you to note that DRBF is publishing a dispute board manual. It's available on the website of the DRBF. It's a guide to best practices and procedures. DRBF has also published best practice guidelines for virtual DB proceedings. And now back to our topic, liabilities of dispute boards and dispute board members. Well, as we all know, dispute boards are a creature of contract. Therefore, the first place to look for any potential liabilities of the dispute board as such, or of any dispute board member, is the contract. The provision of any contract, of course, has to be interpreted in accordance with the applicable law. But what do you do if the contract contains no such provision or they're insufficient? Well, generally speaking, the DBs, the DB members and adjudicators as a species of DB members are not liable for anything done or omitted in the discharge or purported discharge of their functions as DB members or adjudicators, unless the act or omission is in bad faith or fraud, gross negligence, and so on. Today, we will hear from our speakers, why is this the case, how the provisions of FIDIC contracts, for instance, changed from the 99 edition to the 2017 edition, and much more. Our speakers today are Oana Șoimulescu. Oana is a Romanian lawyer specializing in construction law and the founder of Șoimulescu & Partners Construction Lawyers. Her practice focuses on construction law exclusively since 2005. She has extensive experience in dealing with various forms of construction contracts with specific focus on FIDIC forms of contract in Romania and in the Southeastern European countries, where she managed various projects for both contractors and employers. She is experienced in applying FIDIC conditions of contract in a civil law environment, specifically in relation to major projects like transport and water infrastructure, hospital, production plants. Oana's expertise includes an important component of construction arbitration, adjudication, and litigation, being involved as counsel in complex cases throughout the years, involving some of the biggest infrastructure projects in Romania and South European countries such as Albania, Fyrom, and Serbia. Taner Dedezade is an international construction barrister and ICC arbitrator practicing at Corbett & Co. with some 25 years experience, specializing in the resolution and avoidance of disputes arising out of international construction and engineering projects, particularly under the FIDIC forms. Taner is a FIDIC certified adjudicator and on the FIDIC president's list of approved dispute adjudicators. Taner is also a FIDIC certified trainer, FIDIC Trainer of the Year 2020, visiting FIDIC lecturer on the King's Master of Sciences in Construction Law and Arbitration. Taner was invited by FIDIC to train all the members of the FIDIC President list and FIDIC accredited trainers. And Andrew Aglionby is a lawyer and arbitrator with over 35 years of legal practice in the area of construction, energy and real estate, commercial contracts, technology, and media. He has experience of many common law and civil law countries and legal systems. He often advises parties in projects where dispute boards are used. Andrew is the recently appointed DRBF country representative for the UK. He is based in London and practices from the law firm LMB ADR. And without any further ado, I would invite Tanner to introduce us to the world of dispute board members' liabilities. Tanner, if you please.
Thank you very much, Georgiana, for that introduction. And I am delighted to be here today, speaking to you all from different parts of the world. I've noticed a few names that I recognize in the attendees list. Hi, Gustavo from Lima, and Hamish is there, and a few others that I recognize as well. So I'm going to talk, first of all, about the immunity of the sovereign, crown immunity. So I'm sure there are people here that speak far better Latin than I do, but I'm going to give you some Latin. Rex non potest peccare. And for those of you like me who aren't so hot on their Latin, the king can do no wrong. So the idea initially is that the sovereign cannot commit a legal wrong and is immune from civil suit. In other words, it cannot be the defendant in court proceedings, nor can it be involved in criminal prosecution. Now, there are certain countries with royal families where, for example, in Belgium, there was a concept that the king's person is himself inviolable. However, his ministers are accountable. There are countries without royal families. In India and Sri Lanka, immunity of sovereign during their period of office would be the norm. But of course, there might be a procedure for impeachment. And if there's impeachment, then there is a possibility of suing the former sovereign should the impeachment proceedings be successful. There are certain exceptions. In Italy, for example, if the sovereign commits high treason or violation of the constitution, then that might be an exception. You'll be pleased to know I'm not going to go into the details of all the different countries of the world, but I'll say a few things about the UK. In the UK, there is a statute governing the whole of this law, the Crown Proceedings Act 1947. This allows the Crown to be liable in civil proceedings with limited exceptions, but criminal proceedings are still prohibited. And then there is a concept of the royal household. So I'm not going to go into the detail of that at all because it becomes hugely complicated. Who is part of that royal household? Are people in the royal household immune from criminal liability? Unfortunately, there are some scandals at the moment in the center of the royal family, which I'm not going to go into. So the concept is, and this is, you'll be pleased to know, I'm about to move on to judges and arbitrators. The concept is that as a matter of policy, the sovereign can do no wrong. So this concept was embraced when looking at judicial immunity in certain sectors of the world. Judicial immunity effectively is a form of sovereign immunity in that it protects the judge from liability resulting from their judicial actions. So actions unrelated to the decision-making process, of course, will not be protected. So if a judge decides that he's going to shoot somebody in the courtroom, then in those circumstances, that judge will still be potentially liable for criminal prosecution. So we're dealing with actions which are related to the decision-making process, which is relevant. So the basis of immunity in the UK stems from the common law. And any of you who are in any way familiar with the UK will probably have heard of our famous judge, Lord Denning. Lord Denning has always got something to say about anything of any importance. And back in 1974, he said this: "It has been accepted in our law that no action is maintainable against a judge for anything said or done by him in the exercise of a jurisdiction which belongs to him. The words which he speaks are protected by an absolute privilege. The orders which he gives and the sentences which he imposes cannot be made the subject of civil proceedings against him. No matter that the judge was under some gross error or ignorance, or was actuated by envy, hatred, and malice, and all uncharitableness, I never knew there was a word uncharitableness, but there we go, he is not liable to an action. The reason is not because the judge has any privilege to make mistakes or to do wrong. It is so that he should be able to do his duty with complete independence and free from fear. So that was the policy thought process of Lord Denning. So let's move on now to arbitrator immunity. So there's a difference in approach, as I understand it, between the way that the common law looks at arbitrator immunity and the way that the civil law looks at arbitrator immunity. So in the common law, arbitrators are effectively looked at as being immune like judges based on sovereign or judicial immunity. Now, I was just looking at the English Arbitration Act and section 29 of the English Arbitration Act makes it quite clear that in the UK, in relation to arbitrations which are seated with English law, there is a mandatory provision which provides that an arbitrator is not liable for anything done or omitted in the discharge or purported discharge of his functions as arbitrator. And here comes the exception. Unless the act or omission is shown to have been in bad faith. So those of you in the civil law parts of the world will be very familiar with the concepts of good faith. And here we are in the English Arbitration Act talking about bad faith. So maybe there is a little bit of a parity between the way that the common law and the civil law look at things. So I started by saying that the common law arbitrators are often looked upon as being immune, like judges based on sovereign or judicial immunity. My understanding of the civil law, and I'll probably be corrected if I'm wrong by the two civil lawyers on our panel, is that arbitrators are service providers, and that there are service providers pursuant to contractual obligations. So that said, Gustavo will remember that I was in Peru in 2019 before the whole business to do with the COVID came in. And it was widely reported at the time that I was there that the Peruvian Preparatory Investigation Court ordered the preventative detention of 14 arbitrators who sat as arbitrators in cases between Odebrecht, which is the Brazilian construction company, at the center of the Operation Car Wash corruption scandal in Brazil, and the Peruvian government. And those arbitrators were sentenced to imprisonment, pending the investigation of allegations that they accepted bribes from Odebrecht in order to rule in the company's favor in the arbitrations. So there's been widespread concern, as you may well expect, that in both the Peruvian and the international arbitration community, that arbitrators, and included in this process, Mr. Fernando Cantorias Salaverry, I apologize if I've mispronounced that, who's an arbitrator of international renown and who sits on the ICC court, he was one of the members who had been imprisoned, apparently on the basis of an incorrect interpretation of the Peruvian arbitration system, pending the investigation into allegations of corruption. Moving to another part of the world, in the UAE, there was a provision called Article 257, which became quite famous, of the Penal Code. And in that particular provision, the code said that anyone, not qualified, anyone who issues a decision, that of course includes an arbitrator, expresses an opinion, submits a report, presents a case or proves an incident in favor of or against a person in contravention of the requirements of the duty of neutrality and integrity while acting in his capacity as an arbitrator, expert, translator, or fact finder appointed by an administrative or judicial authority shall be punished by temporary imprisonment. So there is a potential sanction of imprisonment in the UAE. Now, people will be relieved to know, after a lot of pressure, that provision of the penal code was changed. And so now Article 257 has been reduced in its scope, and it now says any person who, while acting in the capacity of an expert, translator, or investigator appointed by a judicial authority in a civil or criminal case, or appointed by an administrative authority, confirms a matter contrary to what is true and misrepresents that matter, while knowing the truth about it, shall be sentenced to imprison. So essentially what's happened in Article 257 is that arbitrators, arbitration experts, and arbitration proceedings have now been carved out from the application of Article 257. So Article 257 now no longer allows the imprisonment of arbitrators. So enough of an introduction and a general sort of overview of the immunity of the Crown and the judges and the arbitrators. What about DABs? That's what we're here to talk about. So my own personal experience is very much focused on the FIDIC contract. And in a FIDIC contract, a dispute adjudication board is a creature of contract. As you will all be aware, there is something called the DAA, the Dispute Adjudication Agreement, that is a tripartite agreement that needs to be signed by the three members, the employer, the contractor, and the dispute board member. And within that process, there is when there's been a signature of the dispute board, the dispute adjudication agreement, then that incorporates the general conditions of dispute adjudication agreement. And in that, in those general conditions, there are obligations on dispute board members to have integrity and to maintain independence and impartiality. I'm not going to go into those in any more detail at this point, but it may well be that I'll come back to look at those particular provisions and to potentially give examples relating to the dispute board at a later stage. And it may also be that Georgiana will remind you that there is also a chapter in the DRBF manual relating to ethics. But at this stage, I'm conscious that my time is running out. So I know that Georgiana will probably push me on. So here's my time to go back to Georgiana and say, that's all I'm going to say at this moment in time.
Thank you, Tanner. Andrew, if you please.
Hello, everyone. So it's my pleasure, and I'd like to thank the DRBF for giving me the opportunity just to speak about some of the topics. So we start, I think, with, wouldn't it be nice if the decision makers were in some way immune, as they would be if they were judges, and they might be if they were arbitrators, depending on what the legislation said, because they're making similar decisions, not the same ones, because DABs are not the same as arbitration or court, but similar ones. Well, let's assume that there is no bleed from the immunities that apply to judges and arbitrators over into dispute board members. And honestly, that's a safe assumption. It's not always necessarily correct, but it's, I'd go with that if I was advising someone who came to me and said, oh, I've got this interesting contract I might be able to have for a risky jurisdiction where I'm going to be personally liable for any breach of the contract. That, if I can invite you to just think about that for a moment, that might be what we would get to if this conversation about risks for DAB members became a dominant conversation, and we started putting in place lots and lots of measures to accentuate and increase risks for dispute board members. Because I think if someone then was approached to become a dispute board member, they might start concentrating on their personal liabilities more than giving practical advice to the parties to allow the projects to continue. So there's, I would suggest, a systemic issue to think about, a policy issue to think about in looking at quite how far one pushes this liability. But even if you wish it's not there, the liabilities are the liabilities of a contract. The DAB appointments are a creature of contract. It's a contract between the parties and each of the individual dispute board members, be there one or three. And so, like all other contracts, you have to do the risk analysis. You have to start thinking, well, what does that mean? And you should, I think, start with the terms of the contract. And you should look at how those terms are going to be interpreted according to the governing law. And there's a variety of governing laws. If you look at the nature of some of the projects covered by dispute boards, they're projects of national importance. And there's often, of course, the laws applying in the physical location of that project. So are those the laws which also govern the contract between the parties and the dispute board members? What is the governing law? How is the contract to be interpreted? And also, who's going to interpret it? Is it a court? Is it arbitration? And if it's arbitration, where is that going to be seated? Because we all know that can make a difference, probably more of a difference than the governing law will make to the outcome of the arbitration. What happens when you've got three separate contracts, one for each dispute board member, and they're all covered by different arbitration agreements? Are you sure that they're all going to be consolidated into one dispute? Or might you have separate arbitrations for each of the separate contracts? So which rules do you look at there? And of course, if you're under ICC rules, for example, there are quite extensive provisions for consolidating arbitrations. But these are in fact different parties, aren't they? So are you sure that you're going to be able to have one arbitration which deals with any disputes? So it's the normal risk analysis you would have for making any investment in a different country. The national laws, which might vary, and I've worked, as no doubt all of you have, in countries where it's quite difficult to know what the national law might say about the outcome of any particular dispute. The issue might not have come up before, or there might be no binding precedent. There might have been a change of some nature, which means the law is going to be slightly uncertain. So when you're subject to national laws, what does that mean? Well, I don't have at my fingertips a list of all possible countries and all the differences between them, because the range of those differences is broad. And so if you're in a country where there's a very strong centralized government which has control of the local institutions, for example, then the national laws might be more in favor of one contracting party than the other. But even if you're not looking at that sort of influence, you should be thinking about what's required to create a binding agreement. Is it satisfied, whatever that requirement is in the dispute board agreement? Have you got there? Because, for example, authorizations are required in some jurisdictions. There are limits on signing authorities. In some jurisdictions, if you're dealing with a public project, there are other publication or degrees of authorization which are required. Once you're past those formalities, you've got the terms of the contract, but what about the rest of the law? In the England and Wales jurisdiction, you'd have the common law. In many civil jurisdictions, you'd have the civil codes. What do they mean to the terms of the contract? So this is a big exercise, and having been on the receiving end of invitations to be appointed, they're actually not things which first go through my head when I'm looking at the terms of engagement. You look at the standard terms and you think, oh, okay, I understand that. I know what it all means. Do we really want to move towards a system where this is a real risk for potential candidates for appointment? I suppose it already is a real risk. Moving on a little bit, the normal rule for any breach of contract is that the parties are liable for breaches of contract. And those don't have to be special breaches, they're just ordinary breaches. And the measure of damages, it's differently calculated in different places. But let's call it the normal measure of loss. If you can prove loss, you're entitled to recover it generally. And that's not for special fraudulent behavior or anything of that sort. I mean, I think to generalize, let's split behavior into willful harm. So bias, fraud, something of that sort. The step below that, let's just call it negligent behavior. I meant to do it, but I forgot, or I didn't get around to it, or I did it badly. That would be a sort of negligent behavior. And then there's a level below that, which is a reasonable decision, which might just happen not to be the same decision that later other people come to. So the arbitrators review a dispute board decision and they say, well, it wasn't right. Or one of the parties analyzes the dispute board decision and says, we don't agree. Is that a breach of contract? So there's a level of behaviors and a level of breaches of contract for which there might be liability. And the normal situation would be that each dispute board member would be liable for each breach of contract to the normal measure of loss. And the measure of loss might be considerable. It might be a lot of money. If you think of delay or damages on a big project, these are substantial sums. And you can review those. You can go to the arbitrators, but then you've got the costs of the arbitration. You've got the wasted. Are they wasted? Anyway, the costs that have been incurred in the earlier process, including the fees of the dispute board members. So you're actually talking about quite considerable sums, which might be claimed at least to be damages. So one important thing to look at is the extent and the effectiveness of any exclusion or limitation of liability in the contract terms. And I think then you're back to national law. What terms are effective? What terms are ineffective under the national law applying to each dispute board agreement? And does it catch all or any of these behaviors? So in the FIDIC terms, the general conditions of appointment, for example, there are terms which are effectively exclusion or limitation of liability provisions. But do those work under each of the relevant national laws? who wants to test it? I personally, as a dispute board member, would not like to be the test case for any of these, although arguably that's simply one of the risks one takes in accepting appointments of this type. But one does not have the statutory protection one has as an arbitrator in many, many jurisdictions. And let's not forget, beyond the contract liabilities, liabilities for other legal concepts. So in common law jurisdictions, I mentioned tort, for example, but in civil law jurisdictions, there might be duties of good faith or duties as to the conduct of business. There might be many other duties which are said to arise in the relationship between the parties and the dispute board member. And again, you're back to the relationship between the contractual terms and those duties. Can you exclude those duties? Because many of them are mandatory and cannot be excluded by contract terms. So I think by now I've probably done all I can to put off any competition I might have in the field of competitors for appointment as dispute board member. But it's worth saying this is not a common conversation. I've not come across in real life dispute board members being actually sued, actually arbitrated against, although I have come across in real life the threat to do so in correspondence from a party, often a party that has not succeeded in obtaining its position in submissions to the dispute board. I have come across the threat in that situation of all sorts of dire consequences against the dispute board member. And as a sort of step back general view, what's the right point to take, the position to take to protect the dispute board system, which is a good and effective system for resolving disputes and keeping projects moving and keeping cash flowing? What's the right thing to do to protect that system so that any party who wants to engage in guerrilla warfare, who wants to blow up the system so that they're not disadvantaged, what's the right level of protection to put in so that one balances the party's rights to have the job done that they're paying to have done by the dispute board and the dispute board's ability to keep on going so that it's not hijacked in some way by subsidiary litigation. So that's my comments on contract, and I'll hand back to Georgiana now.
Thank you, Andrew. Well, I'll invite everyone to consider that question, in particular, after listening to what Juana has to say. She's going to bring us 3 case studies about dispute board members' behaviors. And please, after she's telling us the situations, please think about the question that Andrew posed to you. So in the essence, should the dispute board members be fully exempt of any liability whatsoever, or should we have a certain degree of responsibility? I don't know if we would supposed to formalize it, to what level we're supposed to formalize it, or should we more than what we have now, for instance, in the FIDIC 2017 edition, or was it enough what we had in 99? Presumably what we have in 2017 now was brought on by the experience of various people in modifying the pre-existent 99 clauses. So Juana, if you please tell us about your experiences.
Thank you, Georgiana, and thank you all for attending this webinar. I hope we make it interesting for you. Yeah, I'm here to tell you 3 stories, basically. The first story is about a contract and a DEB procedure related to this contract. The DEB procedure referred to three main cases: lack of access to the site, increase of excise duties, and delayed permits, basically delays caused by the authorities. The contract was a 6,000 pages contract, including, as it is typical, design documentation and so on. The DAB procedure was conducted in both Romanian and English, and that required obviously translation of every single document submitted as part of this procedure. At a certain point in time, after having exhausted the time bar objections and so on, in respect of which the DAB issued separate decisions, when reaching the merits of the case, the DAB said, I'm not going to proceed any further before the parties communicate to me the full contract. Both parties agreed and communicated their agreement to the DAB that those parts of the contract which have not been already submitted to it are completely irrelevant to the dispute. And so it should be to the interest of the procedure, to the time and money, aspects, not to translate 6,000 pages, but only the parts which were relevant and were already on the DAB's table. After this communication, the DAB wrote to the parties and said, I will not issue a decision in this case. And that's my first story. The second story refers to another contract. It's still a road contract under the FIDIC Yellow Book, FIDIC 99 edition. And in this case, the contractor referred a case of a failure of the engineer to determine in relation to some of the contractor's claims. After making 2 rounds of submissions, both in Romanian and English, because that's how things work over here, the DB decision came as a complete surprise. He issued a decision saying that the parties should go back to the engineer, and if the engineer fails to issue a determination, then the parties should refer back to the DB. The third story refers to another road contract where parties made 2 rounds of submissions, only in Romanian this time. The DEB did not request any further documents or data. At the end of the day, the decision was issued, and the decision said that the DEB didn't have sufficient information to make a decision, and therefore the parties should come back to the DEB when the project is finished, because it is only then when the DEB can make a decision. Now, before going into what would you think about these cases and what would you do about them, I can tell you that none of my clients, there were 3 different contractors, none of them wanted to take action against the DAB member. In all cases, the contractors requested to be paid back the money, the fees they paid, but all 3 DEBs refused. Before going any further, as I said, I've tried to set up for this presentation some sort of a dictionary. What would be, in this context, the DEB member liability? As Candor put it, the DEB is the creation of the contract. And as the contract provides, whenever the DEB acts or is discharging its functions, the DEB has certain obligations. They are expressly listed in the contract. Liability comes as a consequence of a breach of these express obligations. Just to make myself very clear, I would never think that the DEB is liable about his opinions after having assessed an issue or the decision that he's making. But I do believe that the DEB is obliged to discharge the obligations and the duties listed under the contract, the first of which is to issue a decision in 84 days. And the purpose of that decision is to put the parties in a better position to settle before referring to arbitration or to exclude arbitration effectively. And if the DB doesn't do that, I think that we can look at this issue as a failure to comply with its contractual obligation listed under the tripartite agreement. I would simply leave this to you to comment on these things. How do you think you would approach these things if you would really like to take the DB to keep them liable or to take action against the DB, or whether you think, as I am inclined to think, that in choosing the DB, parties actually make an exercise of trust. Basically, choosing an adjudicator is an issue of trust. So the sanction for not complying with the duties in this way, in not performing as a DB, refusing to issue a decision, or issuing a decision, but in essence failing to decide on the matter, I think that the sanction should be simply withdrawal of trust rather than an action, a proper action against the DB, which would basically affect not only that adjudicator, but maybe the institution, which is not useful for the industry because we know very well the benefits that adjudication has brought to the industry.
Thank you, Anna. Who would like to go first? Tanner?
Yes, I think it's very interesting to hear those examples that Oana has given, and also the question that was posed by Andrew at the end of his presentation. One of the things that it says in a commentary that I have to the 96 Act relating to arbitrators is, if arbitrators were not immune from such actions and they were exposed to an open-ended liability to the parties, considerable harm would be done to the finality of the arbitral process, and it might be difficult to find arbitrators willing to serve at all. And I think the point that Andrew made relating to whether or not dispute board members are going to be worrying about their insurance more than about the job at hand is a point worth re-emphasizing. I just want to add to Oana's 3 examples an additional example, which I had recently. So I was acting for the employer, and the employer approved the contractor's nomination of a dispute board member, wing member. So the DAB wing member signed a declaration which listed out all of the obligations in paragraph 4 of the General Conditions of Dispute Adjudication Agreement, essentially expressly confirming independence and impartiality. And to remind you, there is specifically in paragraph 4b an obligation that the member shall not previously have been employed as a consultant or otherwise by the employer, the contractor, or the engineer. So this is what the dispute board member expressly signed. I was not previously employed. So having received that confirmation that there was independence and impartiality, my client, the employer, decided, well, I'm going to sign the dispute adjudication agreement. There should be no problem. It subsequently transpired that just prior to providing the declaration of independence, with no disclosure at all, that the contractor had instructed the dispute board member as counsel in a separate ICC case. So nothing to do with the project, but there had been an employment of the DAB member by the contractor that had not been disclosed. So when this was discovered, the employer pointed out that the DAB member had knowingly made a disclosure statement that was false. He said, I haven't been employed by the contractor, when in fact he plainly had. So when my client wrote to the dispute board member, the dispute board member said, okay, I'm resigning. But as is the case with Oana's 3 examples, he refused to reimburse any of his fees. So the matter that arises in relation to my example, and it also applies with Oana's, is particularly for mine, how does the wing member influence, in my case, the dispute board when it reached its decision? So we know that the wing, well, there's an inference that the wing member was in some way having some connection with the contractor. He'd been instructed by the contractor. There appeared to be at least a professional relationship between the contractor and that DAB member. How much and to what extent had that relationship impacted the dealings of the rest of the DAB? And perhaps more interestingly, what becomes of the dispute board's decision? Does the dispute board's decision automatically become void or ineffective in the way that is described in paragraph 8 of the rules? And I'll come back to the rules in a moment if I've got time. To what extent should the remaining dispute board members engage with the parties to provide answers to whether they knew or not about that DAB member's non-disclosure? These are all questions I have. I don't know if I've got time, but I think I should probably very quickly go through the dispute board rules or the relevant provisions. So provision 3 makes it clear that a member warrants independence and impartiality. It has an obligation to disclose any fact or circumstance which might appear inconsistent. And then in paragraph 4, as I've already mentioned it, there's a whole host of obligations that the DAB member has to sign, saying effectively that it will comply with. And then the more difficult part of the provisions are contained in paragraph 7, 8, 9, and I'm talking about the FIDIC 99 forms at the moment. So in paragraph 7, there's a termination provision which allows the parties, but it has to be both parties, to terminate the DAA in the situation where a member fails to comply with the dispute adjudication agreement. And it goes on to say in paragraph 8 that if the member fails to comply with clause 4, he shall not be entitled to any fees or expenses. He's supposed to reimburse those. But what if the DAB member refuses to do that? Well, the last part of the sentence in paragraph 8 talks about the circumstances in which the DAB's decision is rendered void or ineffective, but it's not clear in what circumstances it would become void and or ineffective. The only thing you can do under paragraph 9 is take the matter to the ICC. Just like Oana's clients, the contractors in her case, the employer in my case, my client wasn't interested in taking this dispute board member to ICC arbitration. So just very quickly, how's it changed in 2017? Well, there's still a provision in paragraph 4 of the independence and impartiality obligations, but now we've got an extra clause in 8.1c, which provides that a member shall not be liable for any claims for anything done or omitted in the discharge or purported discharge of the DARB member's functions. And then there's the exception, except in the case of fraud, gross negligence, deliberate default, or reckless misconduct by him or her. So I asked the question, I know that Oana's cases were under the 99 forms, but if they were under the 2017 forms, did what my DAB did or what Oana's DAB in the 3 examples, did what was their position potentially fraud, gross negligence, deliberate default, or reckless misconduct? What should happen? So let's put that question to the audience, perhaps with permission from Georgiana. What, if anything, should a party do? Should they potentially pursue a dispute board member? What kind of liability do you think a dispute board member should have? So you've got on the one side the rationale for why they should be immune, because if they're not immune, they'll end up being fearful of even potentially putting themselves forward. And you've got on the other side those members who might not actually respect those ethical obligations and or do what one might expect, as Oana put it. They have a mandate. It's a contractual mandate for the parties that they should fulfill. So what do we do? Where do we draw the line?
I would be tempted to ask first those DABs or DB members who are with us today from their perspective, because they would know very well the pros and cons of these situations from their own experience. So perhaps, I don't know, Florin, would you like to come live, or Hamish or Ian or Simon? Any of you would like to come on live and tell us, what do you think? Michael? Very shy today. Okay, Simon, I'll bring you on. Simon, can you? Okay.
Well, I've unmuted. I'm looking for the video. Oh, there it is.
Okay, here you
Right.
are.
Hello, everybody. I'll probably give you an answer which this is going to sound just like a lawyer or a politician. My apologies to the lawyers there. I think it, first of all, is obviously dependent on the depth of the negligence. And I think this is where there's such a grey area in law, and I'm not a lawyer, but I know that when it comes to proving, I think, Tanya, you said gross negligence was amongst that list. Negligence is difficult. I think, if I'm not mistaken, negligence, there has to be intent. Correct you. I'm sure Andrew or Erna will tell me if that's right or wrong. Morally, ethics-wise, it's very wrong. Would you pursue it? I've avoided the first answer. Would you pursue it? ICC, look at the costs of going to the ICC and look at the amount of fees you've paid in advance. I believe that your answer is probably going to be it's not worth it.
But if you would have been in one of the situations that Juana and Tanner described, don't you feel that that dispute board member should be liable somehow, or you know, something to prevent that from happening in the future?
Absolutely, I would agree with you 100%. There has to be some responsibility, and you have to take responsibility. But I'm not terribly sure how you do it, unless you have a provision in there that enables one party, in the event of such, to terminate that agreement. You still are talking about the loss of fees. And again, we come back to, has that negligence been proven? It's a very difficult situation. It does require a lot of thought. It's not easy.
No, obviously. So that's why we're here today. Not only is not easy, but I wouldn't go for one party only. I would be tempted to say that parties together should do that, because you don't want just the disgruntled party to actually go ahead and abuse this.
I accept that, but for me, the reality on the ground is that often a situation like that, one party might well be wanting to frustrate the situation. And here comes a perfect opportunity to frustrate, particularly perhaps if a referral has gone ahead and they feel that they do not have good grounds to have a decision in their favor.
Thank you, Simon. Juana, what do you think? Would you like to add something or? And
I would still put again on the table the issue of withdrawal of trust, because it is still in your control as a contractor or as a party, the frustrated party in the DAB procedure, let's say, not to appoint that DAB the second time. And this is one way to deal with it. One other way to deal with it is to write to the appointing authority, just in case the appointment was made by an appointing authority, be it the ICC or FEDEC or whomever, but in any event, those institutions, because they have to preserve by all means their credibility and the trust of the industry, they have to know about these things. And it would be, I think, up to them to call any kind of discussions with the member or the parties and so on and so forth. But I believe that indeed it's truly not efficient to go to ICC arbitration with such a case. It's not worth it, as Simon put it, because you still have the possibility to issue a notice of dissatisfaction in relation to the failure to issue a decision. So you would still you still have your preliminary stage done, and you can achieve the arbitration decision, which is the ultimate goal of the procedure.
Georgiana, if I may.
yes, please.
Hi, just to answer the provocation you launched earlier on. Sorry, I was listening to this webinar in the strangest way ever, as I was doing some repairs to my roof because of some owls which invaded my space. Sorry about that. So to answer, somebody behaving as Taner and Juana said, I believe should be shot at sight, to be very brief and sharp. Definitely that should not be done by any DAP that have any minimum respect for himself, let alone for the parties that hired him and for that profession. In brief, I believe any DAB member should always, but always disclose any remote possibility that any very past relationship might be perceived even as biased or in any other way which the parties may not appreciate. So my suggestion is for any DAB member, anytime, just let know the parties about everything, regardless how far in time or how remote it was that relationship, disclose it, put it in writing, make it clear, and let the parties make the decision if they're happy with that or not. Therefore, you can explain, obviously, I've been hired, I don't know, 10 years ago. There is no further relationship or privileged relationship after that collaboration. I have been paid for my services. That party have nothing against or for me following that collaboration. I have nothing for or against that party. And as far as I'm concerned, I consider myself as impartial, but I invite the parties to assess that, draw their attention, and let them have their say. Full stop. Thank you.
Thank you, Florrie. Hamish, very quickly, please, because we are getting to a close, please.
Yeah, what I would recommend is that you do your job as an adjudicator as well as you can. I'm reminded of 4 aspects of doing that that Lord Rennie mentioned in the previous webinar, and that is to act with candor, to act constructively, to have a little bit of humor, because that always lightens things up, and don't be stupid, right? At the end of the day, if you're looking for negligence, and I wouldn't argue necessarily with the previous speaker, but negligence doesn't have a need to have any intent. But basically, do the job that you've been asked to do. Your qualifications are there to do the job. And if you make a mess of it, then you're only yourself to blame. But you will get parties that don't agree with your decision, but that's tough, that's life. As long as you've done the job properly, then there shouldn't be any comeback.
Thank you, Hamish. If any of you, Andrew, Juana, or Tanner, have anything to add, please, as conclusions.
You're muted, Andrew.
Very 21st century contribution there. So I would just say thank you very much. That's really helpful. I think I had one further thought, which is about how you change as a decision maker from the very beginning, the very first decision that you're invited to make, through to the tens and then the hundreds and so on. And that's a journey, and you can get better or worse, I suspect, but certainly in terms of being a bit thick-skinned about criticism, it's easier the more you've done. And I think there's a role to play in making clear how much exclusion of liability there is in particular for the new appointees. And there are so many new people coming onto the FIDIC president's list for appointment that for me, this is a real point, that there's a role to play in saying, don't worry, you're not going to lose your house.
Thank you, Andrew. Juana? You're mute.
I would like to thank all the participants for taking their time to listen to these cases. And I truly believe that this will somehow be dealt with smoothly, rather than turn into very aggressive suits against DB members. Hopefully that would be also addressed at the level of training, and I'm sure this is already in place.
Thank you, Anna. Tanner?
I second what Oana's just said. Ultimately, raising awareness on the sort of issues that we've shown in these examples that we've given, and ensuring that dispute board members will satisfactorily fulfill their mandate and do so to the best of their abilities, hopefully should be enough, without us having any sort of sanctions, which Florin suggested, shooting them, I think, may not be the answer.
Well, Florin likes to be dramatic. We know that he likes to use a very colorful language. No, we wouldn't go so far, but they know who they are. And I would perhaps, reverse to a more primary school punishment. Write down 100 times the canon of ethics of DRBF, and don't do it the next time, because it's your reputation, it is your future as a DB professional on the line. And even if it's nothing put in writing, there is a lot that the word of mouth could do and damage your career. Thank you very much to all the speakers today. Thank you very much to all the delegates who have joined us today. And I'm looking forward to see you as soon as possible. Remember, we have a very robust calendar of events. If you check the DRBF website, you will find a calendar there where you could see more topics that might be of interest to you. And don't forget to join us to the next conferences that we are going to have for you. I guess it's, if I remember well, August is Indonesia. Then we have Peru and Brisbane, Australia. And October, we go coming back to Europe with Romania, Cluj, the Halloween party. Please join us. And hopefully the end of year in The Hague. Thank you very much for today. Thank you. Goodbye.
Thank you.